Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome to the Arbitration World podcast. My name is Jackie Celender. I'm an international arbitration and complex commercial disputes partner in the Pittsburgh office of K&L Gates. We are delighted to bring you this episode and a series of podcasts on key cases and developments and trends in the United States that are having an impact on international arbitration in the U.S. and across the globe. On this episode, we will discuss the oral argument recently heard by the U.S. Supreme Court in Morgan versus Sundance, dealing with the question of whether parties to arbitration agreements can be found to have waived their right to compel arbitration only where the other party is prejudiced in some way. My colleagues have also recently written on this topic, and you can find that article along with other international arbitration content in the thought leadership section of our International Arbitration Practice Group's website at klgates.com. Joining me on the podcast today are my colleagues Lindsay Bishop and John Gavin. Lindsay is a partner in the K&L Gates Boston office and a member of the International Arbitration Practice Group. John Gavin is an associate in the K&L Gates Boston office as well, with international arbitration experience. With that out of the way, let's jump into the topic of today's episode. As I mentioned at the outset, the central issue in the Sundance case before the Supreme Court is whether parties to an arbitration agreement can be found to have waived their right to compel arbitration only where the other party is prejudiced in some way. Lindsay, why is this an issue that matters? What are the practical implications here?
Thanks, Jackie. It is great to join you today. This issue has caused a split among a number of the federal circuit courts of appeals and has the potential to lead to different results in similar situations. It also presents the possibility that arbitration agreements may be allowed to stand where other agreements, given the same facts, would have been found to have been waived. This is particularly relevant in light of the Supreme Court's instruction in a prior case that arbitration agreements are to be placed on an equal footing with other contracts. Additionally, arbitration agreements are commonplace and becoming more and more prevalent. So having a uniform national standard for waiver of such agreements would provide peace of mind to contracting parties on both sides and give clear guidance on when they may be bound by such agreements.
Thanks, Lindsay. John, could you walk us through an overview of the law in this area and how courts look at questions of waiver of contractual provisions?
Certainly, Jackie. So in the context of normal contracts, that is, contracts other than arbitration agreements, there are essentially two ways in which a party can lose rights under a contract: waiver and estoppel. Waiver can be either explicit or implicit, but boils down to the intentional relinquishment of a known right. At its simplest form, waiver asks, did the waiving party know of its right and act in a manner inconsistent with that right? Estoppel focuses on the impact on the party raising estoppel. The estoppel inquiry is, was there a representation by one party which the other party reasonably relied upon when changing its position to its detriment? Estoppel asks not what did the estopped party intend, but what was the impact on the other party?
Lindsay, what does that look like in practice?
Sure. So let's say there is a contract for the shipment of 10 cars per month. The buyer can waive its right to those 10 cars in a given month by saying to the seller, hey, I know our contract says 10 cars a month. I don't need the cars this month. Don't send them. That's a pretty clear-cut example of waiver, no matter what the seller did in response to those words. But now let's say the buyer just doesn't pick up the cars for a few months. And after 3 months of not picking up the cars, the buyer comes back and says, hey, where are our 10 cars for this month? But the seller has already sold those cars because they thought the buyer was done buying cars. In that case, the buyer could be stopped from asserting its right to those 10 cars if the seller's actions were reasonable.
Thanks. That's a helpful overview. You mentioned earlier that circuits are currently split on this issue. Can you walk us through that circuit split?
Gladly. So this issue has caused a 9-2-1 split among the circuits. 9 circuits have explicitly held that a showing of prejudice is required to find waiver of an agreement to arbitrate. The 7th and DC circuits, meanwhile, do not require prejudice to find waiver. The one remaining circuit, the 10th Circuit, takes a middle-of-the-road approach, listing prejudice as a relevant but not necessary factor to finding waiver.
So let's now dive into the case before the Supreme Court, Morgan versus Sundance. John, can you give us a little background on what the case is about?
Sure, Jackie. The petitioner in that case, Robin Morgan, was an employee at a Taco Bell franchise owned and operated by Sundance. As part of her employment application, Morgan signed an agreement that required disputes with Sundance to be arbitrated. Despite that agreement, she filed a class action lawsuit against Sundance, alleging that during her employment, they committed a number of Fair Labor Standards Act violations, including failing to pay overtime and forcing employees to clock out but continue working. In response, Sundance moved to dismiss or to stay Morgan's lawsuit in light of another pending class action against it in Michigan, which was based on the same allegations. When that motion was denied, Sundance answered Morgan's complaint and did not assert its right to arbitrate. Sundance, Morgan, and the plaintiffs in the other lawsuit then had a joint mediation, which involved some limited discovery. After the mediation, the other lawsuit settled, but Morgan's lawsuit did not. Then, 6 months after filing its motion to dismiss, Sundance moved to compel arbitration.
And how did the court respond to that motion?
Well, the district court found that Sundance had waived its right to compel arbitration because it had acted inconsistently with its right to arbitrate by engaging in litigation for months. The court also found that Morgan was prejudiced by the delay because she had to defend against the motion to dismiss and engage in class-wide mediation instead of participating in individual arbitration.
So the court required and found prejudice then?
That's correct. The Sixth Circuit had previously held that prejudice is required to find waiver, and applying that precedent, the district court found prejudice in this case. However, the Sixth Circuit reversed, finding that Morgan was not prejudiced. It is important to note, however, that there was a dissenting judge in that opinion who noted that prejudice was a, quote, debatable requirement to find waiver.
So jumping into the oral arguments, this seems like a lopsided circuit split. You have 9 circuits going one way, 2 circuits going the other, and one in the middle that seems to be leaning towards the majority. Did that come up at all in the arguments?
It did, Jackie. Early in the petitioner's argument, Justice Alito acknowledged that even though the petitioner had a strong and cogent argument that might be right, they were asking for a sea change in the law.
I thought the petitioner did a nice job addressing that point, though, arguing that while it might be a sea change on this specific issue, it fit within a wider trend of the Supreme Court requiring contract interpretation and defenses to be analyzed under state law, which in most cases does not require prejudice.
What was the petitioner's position on whether this was a question of federal or state law?
They actually took the position that it is both. The petitioner argued that in cases of alleged waiver of an arbitration agreement, there should be a 2-step inquiry. First, is the agreement to arbitrate enforceable under state law? And then second, if so, is the party seeking to compel arbitration in default under Section 3 of the Federal Arbitration Act? Under the petitioner's argument, the question of waiver is addressed in the first step and would be governed by state law. The petitioner also argued that the second step default inquiry also does not require prejudice.
So if this is a state law question, is it the case then that there are ostensibly 50 different sources of law out there on whether an arbitration agreement is waived or not?
Yeah, and the court did seem concerned that that might slow things down in arbitration. The Chief Justice asked whether asking federal courts to apply state law here would lead to increased complexity and delay, particularly if the federal courts had to resort to certifying questions to the relevant state Supreme Court.
Although here again, the petitioner had a good answer, pointing out that currently parties to arbitration agreements can spend a lot of time fighting in federal court just to end up in arbitration once one side decides to enforce the arbitration agreement. The petitioner cited to one case, MicroStrategy versus Lauricia, in which the Fourth Circuit compelled arbitration despite the fact that the parties had engaged in 2 previous lawsuits on the issues, had filed over 50 motions, and had taken depositions. And despite all of that, the Fourth Circuit found no prejudice and sent the case to arbitration.
And the petitioner also acknowledged that nuances in how states deal with waiver and estoppel would have to be allowed to control arbitration agreements as well, so long as the treatment is uniform. That is, state law applies the same elements to waiver in the arbitration and non-arbitration context. So, for example, New Mexico and Vermont have merged the defenses of waiver and estoppel for all contracts. Under the petitioner's reading, prejudice would be required to find waiver of an arbitration agreement in those states because it is always required.
And what was the respondent's take on that issue?
The respondent argued that the state law question is whether the contract is valid in the first instance. Then there is the federal question of whether the party is in default, which the respondent says is limited to cases where a party violates a contractual term or court-imposed deadline. According to the respondents, questions of waiver and estoppel under state law are for the arbitrator to address after the case has been referred to arbitration.
So, John, at the end of the day, did the parties each articulate a position as to what would constitute waiver under their proposed standards?
Yes, they did. The petitioner indicated that they thought waiver should be found if arbitration is not raised in the first responsive pleading, be that a motion or an answer. The respondent, on the other hand, argued that waiver should not be found until the parties have engaged in, quote, substantial discovery.
Well, it will certainly be interesting to see how the Supreme Court resolves these issues when it publishes its decision, which I understand we hope or think we can receive by the end of summer 2022. On that note, Lindsay, can you wrap us up here by telling us about some of the potential implications of the court's decisions on this issue?
Absolutely, Jackie. Yes, a decision on this issue has the potential for major implications. If the Supreme Court adopts the majority position and requires prejudice to find waiver, a situation like Morgan could repeat itself, where a plaintiff is forced to spend time and money to take discovery and participate in early motion practice, only to be forced into arbitration later. On the other hand, if the Supreme Court rules that prejudice is not required to waive an arbitration agreement, it will require parties seeking to enforce such agreements to act promptly to preserve that right by asserting it as soon as possible. We're just going to have to wait and see what the court does.
Well, thanks, Lindsay and John, for the discussion today. And thanks, everyone, for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you'll join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.